Okay, I think we're going to go ahead and get started. Good morning, everyone. As I was saying, thank you so much for joining us today. My name is Kate Ramos. Sorry, Maria has a hand up, yeah? Um, Maria, do you want to unmute? There we go.
Yes, can you hear me?
Yes.
Okay, great. I was trying to figure this out. Okay. Good morning.
Good morning. Okay, so good morning, everyone. My name is Kate Ramos. I'm a managing attorney with the National Immigrant Justice Center. We are a nonprofit. We're located here in Chicago, and we have been, very happy to be working with everyone in sort of dealing with this response, and really thankful to all of the support that we've been receiving from everybody. And I did just want to take a little bit of time this morning to sort of give you a summary of, now that we're a few weeks in, what we are seeing from an immigration standpoint, for the people who have been arriving on the buses, and also sort of giving you a summary of some of the information that we've been giving them, next steps, and then also sort of empowering you and giving you all some of the tools as well, so that if they do come to you with some questions, that you'll have some resources to share with them as well. I'm going to go ahead and work through the presentation, and then at the end, we'll have some time for questions. Just since this is a slightly larger group, I want to make sure that we get through all of the information. I will admit I am a little bit new to Zoom, so please be patient with me as we do this. But I am going to go ahead and share my screen and we can get started. Okay. So hopefully everyone can see my screen. And I do, like I was saying, just want to thank you all for being with me this morning. Just a brief agenda for what we're going to be going over. So who are we seeing? Who is arriving in Chicago? What is sort of their posture? Give a summary of sort of what our legal services response has been, really our focus on meeting the immediate needs that we're seeing. We're going to talk a little bit about deciphering the current procedural posture that people are in, and then what they need to do to comply with their ICE and EOIR requirements. I'm going to very, very briefly touch on asylum claims and some other forms of relief. I know that there have been questions about that, so I do want to give just some very basic, broad information about those statuses. And then, as I said, we'll open it up from questions. So who are we seeing? I will be honest, I pulled these numbers about on Wednesday evening, so they are probably very out of date by now, as I know we receive high numbers of people every day. But as of Wednesday, we had about 609 people check in with us at our table at the mark, or excuse me, 680 people check in with us at our table at the mark. I know that we did not manage to get all of the children who came through, and I know that there have been some times when we have not been able to write down everybody's sort of biographic information, just because we have been trying to get through as many people's questions as possible. But the vast majority of the people that we are seeing are from Venezuela. And I am not an expert in geopolitics in Venezuela, but as we all know, that they are fleeing the conditions of their country in Venezuela, that things are incredibly difficult right now. So we have seen a wide spectrum of countries represented, most of which are Latin America. We did see 2 people from Iran as well, who did come to see us in the mark. Ages are, majority adults, which is what we expected. As I said, I know we haven't tracked all of the children. We've really been trying to focus on meeting with the adults as they come through. We are not seeing a large number of seniors, but we have seen mostly adults. And I know this is sort of the question that people have been asking a lot, is what is the procedural posture? So the notice to appear, and I'm going to discuss this in more detail later, but the notice to appear is really the document that starts the deportation process in front of the immigration court. So one thing that we have been tracking is who's been issued a notice to appear. Are they in immigration deportation proceedings yet, or are they being given a chance to sort of pursue other forms of relief prior to deportation? So as you can see, the vast majority of the people that we have come in contact with are not currently in deportation proceedings. They have not received that notice to appear. They are not appearing before the immigration court. In fact, out of all of the people that we've seen, only 21 people have been in deportation proceedings. I will also caution that although some of them have been issued notices to appear, we have noticed that not all of those are actually what the Supreme Court has designated a valid notice to appear. So they may not actually be in deportation proceedings yet. They may still sort of be in the preparation stage. But really, I do just want to make it very, I know this is very technical already to start, but that we are not really seeing people who are yet in deportation proceedings. What we are seeing is that they have been granted parole. So they have been paroled into the United States to seek some other form of relief. And we're going to sort of talk about that in a little bit more detail as well. So if you had come to one of the other presentations I came, you may recognize this page. So this is our sort of summary of actors in immigration cases. So really just about everyone that we are coming in contact with is falling into the section under DHS. That's who they've been having contact with, and that's who they're going to continue to have contact with for the time being. So they have come in contact with CBP, or Customs and Border Protection, when they entered the United States. Their next step is these check-ins with ICE, Immigration Customs Enforcement. So this is where they are getting those notices to report and presenting themselves at the local ICE office. If they are moving forward with asylum applications, which it does sound like there are people who have valid asylum cases, then they would be applying in front of USCIS at this point, and with the asylum office. As I said, we've only seen a very limited number of people who are in front of DOJ and who have those notices to appear. And so they will be pursuing their cases in front of the immigration court. But the vast, vast majority of people are really right now still located within sort of the DHS section of immigration law. So what are we doing when people come to the MARC? Because I know this has also been a question that comes up a lot. So the first thing we're really doing is just meeting with people and collecting their basic information. So a lot of the information that I presented earlier, so country of origin, whether or not they've been issued a notice to appear, and then whether or not their intention is to stay in Chicago or to go to another city. One of the things that we are trying to track is where they have been, what addresses have been placed on their existing documents. I will say that I have done some brief Googling of addresses that are on documents, and most of them seem to be churches or homeless shelters all throughout the country. I did have one gentleman tell me that he was told that the address that they put on his documents was a homeless shelter in Philadelphia, and that shelter would be expecting him. But we do sort of just try and gather that information. We're trying to get sort of a global picture of what where people are coming from and what their needs are. From there, we are breaking into groups of about 10 people at a time, and we're doing orientations. So really, these orientations are geared towards people who have not yet been placed in removal proceedings. And we are sort of going over what their next steps are. So, is their next step to check in with ICE? Is their next step to update their address with ICE? How to contact ICE in the immigration court, things like that. Now, as I mentioned, we do have some people who do have those notices to appear. So we do know that they are possibly in removal proceedings. So those people we are meeting with still one-on-one, going through their documentation and trying to provide updated information for them and resources so that they can be successful in any immigration court cases that they have. We are also distributing materials. So by the end, I will put in the chat the packets that we have been distributing, and I will also send around sort of an FAQ that we've put together. But we are making sure that when people leave our table that they do have a packet with really clear next steps, a really good summary, I think, of the immigration process. We're also providing them with referral lists to as many nonprofits as we can in the city of Chicago and in the state of Illinois who are taking or who may be taking immigration cases. We also are giving them really directed information about how they can contact ICE, and then information for how they can get back in touch with us if need be. One thing that I do want to stress is that at this time, we are not doing individual legal consultations. We just, with the number of people that we are seeing at the MARC on a daily basis, it's really not possible for us to be doing one-on-one legal consultations in the MARC space itself. We are really just trying to provide as much referral information to participants and really focusing sort of on the next 60 days, which is what most of them have for their parole and what their immediate response needs to be. So I do really quickly want to go through some of the packets of papers that we have been seeing, because I know a lot of you get shown those at the shelter. And so this person very kindly allowed us to put together a redacted version of the packet that he has. So they are receiving these packets from Customs and Border Protection. A lot of times what we are hearing is that they do have their passports and their state IDs taken away from them at the border, and they are being told that this document basically serves as a form of identification. It does have that very general identification information on it, right? So they do have their names, date of birth, and place of birth, although I have had multiple people tell me that their names are spelled wrong or that place of birth is incorrect. Those are all corrections that they can make when they meet directly with ICE or when they send ICE any sort of confirmation or check-in information. One thing that I do think is really important, and I want to really highlight for all of you as well, are the identification numbers that are present on this document. So I do want to draw your attention here to the subject ID. This is an ID that is issued to them by ICE and Border Protection when they enter the United States. And it is an ID number that they may need to disclose in the future. The more important one, however, is this one here that you would find in box number 11. So on this form, it's called their file number. You'll also see it commonly referred to as their alien number or their A number. It is consistently 9 numbers and it starts with the letter A. The majority of people that we're seeing their 9 numbers do seem to be starting with 243. And then beyond that, it is an individualized number for them. You don't always see the letter A on all of their documents, but this number is really critical. And honestly, I've been telling everyone that they do need to memorize this number. It is essentially their identification number with immigration moving forward. So any documentation that they turn into immigration and any documentation that they receive from immigration should have that A number on it. And this will essentially remain their number for the duration of their time in the United States. So if they are ever issued a work permit, that number will be on their work permit. When people become citizens, that number will appear on their citizenship certificates. So it is really an important number, and it is also a very useful number, which we'll discuss how we can use that moving forward. But really, those are 2 numbers that I do want to make sure that everyone is aware of and that they know where to find on the documentation. So the next thing that people are presenting us with is a page that looks like this. So again, on this number, on this page, you will see that right up here at the top, once again, we have that file number. So that's going to be that identification number that I just talked about. So, even right here on the second page of their documents, it is showing up in just about everything. Now, you'll notice one thing that is really important for a lot of our participants is this number here. So essentially, this page is the explanation of their parole, or libertad condicional, that they have received from Border Protection. Essentially, it is telling them that they are obligated to report to the closest Immigration and Customs Enforcement or ICE office near their final destination within 60 days of arrival in the United States. This is particularly important because as we've been seeing more and more people, we've been noticing that they are not necessarily being issued programmed appointments with ICE offices. They have just been given this page and told that they must present to the local ICE office within 60 days. I do want to draw attention to the 60 days, however, because we have seen some variety on that. One thing that I have noticed is that we have seen a number recently of people who have been given only 15 days to present to the local ICE office. I will also note that that tends to be people who have already designated their final destination as Chicago. And so their documentation is addressed to Chicago. And at that point, they are not given 60 days. They're only given 15 days. If you are looking at this, one thing you may notice is that this entire page with all of this really important information is in English, which means the vast majority of the participants that we are coming in contact with cannot read or cannot understand this information. I have seen a number that do have some Spanish translation, but the vast majority that we have received have been in Spanish. So if somebody does hand you their packet of information and they're asking, what is my status? What am I looking for? This page in particular is really important because this is the page that is identifying that they have been granted parole. Now, if they are granted parole, this also means that they are not yet in deportation proceedings. It could change, but as of these 60 days, they are not in deportation proceedings. They do not have a court date in front of the immigration court. Everything they have is with Immigration and Customs Enforcement. Now, one thing that I know can be confusing for people is when does those 60 days run, or 15 days? So as you're going through their papers, everyone is going to have a stamp that looks like this. And this is particularly important because this date right here is the date that their parole is going to expire. So for this particular gentleman, his 60 days will run on November 18th of this year. 212D5 is the section of the Immigration and Nationality Act that relates to parolees being admitted to the United States. 9/17/22 is the day that he entered. EPT is the signal for Eagle Pass, Texas. And then this would have been the identifying information for the officer who admitted him to the United States. One thing that has also come up a lot about these stamps is that, just as a reminder, the United States we write our dates a little differently than the rest of the world. The rest of the world generally writes their dates day, month, year, whereas we write our dates month, day, year. So I did see a number of people, particularly in the past week, who their parole expiration date said 11/10/2022. Now, for those of us who are raised here in the United States, who are comfortable and aware of how we write dates, we all know that that meant November 10th, 2022. And that seems like a fairly basic concept to all of us. But to the majority of the people that we saw at the mark who had that date, they read that as October 11th, 2022. So in all of their minds, their parole ended on October 11th rather than November 11th. So really, when people are coming up to you and they're freaking out about their dates possibly expiring, it's also a good idea just to look at them and make sure that they do know how we write our dates here in the United States, and that we do month, day, year as opposed to day, month, year. The other thing that is very important about this document is that this is really their only proof that they have entered the United States with the permission of the US government. So even though this document is going to expire on November 18th, it is still going to be this gentleman's only proof that he is here with permission, right? That he has entered with inspection, he has been paroled into the United States. So later on in his sort of immigration journey, he will need to submit a copy of this stamp proving that he was inspected and admitted and paroled into the United States. So it is really important that people continue to save these stamps. If they do have phones, I have asked them that they take a picture and save it or email it to themselves or send it to a friend. Really making sure that they have these stamps is critical. The example that I give to most of the people at the mark is that I do have a client of mine who did enter on parole to seek asylum. While her asylum case was pending, it took about 7 years. She met a US citizen. They are married. They have a lovely little boy. And he was able to apply for her, and she was able to become a permanent resident here in the United States because she had this stamp that indicated that she had been paroled into the United States. So it is really important, not just for the course of the next 60 days, but really for the course of their entire immigration journey in the United States, that they do protect and keep these stamps. Now, a lot of them have these pages as well. Again, we have redacted it. For the most part, this is an explanation of what they will need to bring to their ICE office appointment. Thankfully, this one at least is in Spanish, and it does explain basically how they can find the closest ICE office to them. So it does have a phone number that they can use for that, that they need to present themselves within 60 days. If I have seen that if they've been switched to 15, the 60 is crossed out and someone has handwritten 15 on. I've also seen some where they did not cross out the 60 and wrote 15. My advice would be that anywhere where they have 15 days written anywhere in their documents, they need to look at those 15 days as the controlling date. It also says which documents they need to bring with them to present at their appointment. This is really really challenging for a lot of the people that we've been seeing because, as I mentioned, a lot of their documents have been confiscated at the border. So they may not have these proof of identity documents because they're already in the possession of ICE. But in that situation, we would still really strongly encourage them to continue to go to those appointments. They just need to bring this packet. Again, it's going to have all of their biographic information on it. It has their photo, it has their fingerprint. So for the purposes of ICE, this would serve as a form of identity. Now, I do just want to highlight the address that they put on this form. So you can see here where it says domicilio. Excuse me, sorry, there's my pointer. I happened to Google this address because I was curious what this address was, because the client told us that he had no idea what this address was, that he hadn't given them an address, and that the officer had gone ahead and put that in his documentation. This address is a church. It is a church in El Paso. So this is really something that we are seeing across the board. And I know we've seen this locally as well, that people are being given addresses that do not actually pertain to them. I've seen many of the ones here in Chicago seem to be the address, at least in the past few days, were for a homeless shelter in Humboldt Park. There does not seem to be any confirmation. We know there has been no confirmation, at least locally, between ICE and any of these locations where they have been sending people for these appointments, or saying that their addresses are. So these addresses really do not belong to our clients. And I, for the most part, have not expected any of these addresses to belong to our clients. Very rarely they might. And this is something that all of our clients and participants have been very concerned about, because they want to change this address with ICE and make sure that the address where they are currently living is the proper address. So almost all of them in their packets have a page that looks like this. And this is a list of the majority of the ICE offices here in the United States. And it has all of the contact information. So for example, for Chicago, you will see right here that it has the address. It's 101 West Ida B. Wells, 4th floor. It has the phone number for that office. And then it has this email address. Now, we've been given a different email address than this one, and so I will go over that with you. But these are all ways that our participants can and should be attempting to get in touch with the local field office to change their address and update their address in the ICE system and throughout the entire immigration system. I will admit that this has been challenging for most of our clients. I know that people have been trying to go in person. I have been told that the voicemail box for the phone is full. We are still continually trying to advocate both on a national and local level with the ICE office to get some sort of concrete explanation for how they would like us to explain to people how they can get in touch with the ICE office. But this is something that we make sure that we highlight. This is also important because if people are not staying in Chicago, it also has on it many of the field offices for other parts of the country as well. So for example, if they're going to New York, it has the New York field office. If they're going to Philadelphia, it has the contact information for the Philadelphia field office as well. So this is really a page that is generally important to everyone. Now, some of the people that we've been seeing have a page that looks like this. And this is the form for the Intensive Supervision Appearance Program. Now, traditionally, when someone signs this form that they are being placed into the supervision program, they're then given a phone number by ICE that doesn't see, or a phone by ICE or by Customs and Border Protection, or an ankle monitor has been placed on them. That does not seem to be happening. Instead, what they are being told to do is that they have to call this phone number once they arrive at their final destination. Now, this example does not have a deadline on it. I have seen some where they have been told that they do have to call this number within the first 7 days of arriving in their final destination. So if someone does bring you this packet of papers, I really would just strongly encourage them to call this 800 number and let ICE know that they have arrived. I have also been told by people at the MARC that this phone number is also not currently being answered, that there is a voicemail box. And so we are just encouraging people to continue to leave messages in that voicemail box. I know it is a struggle for people who do not have phones, but I am very grateful to all of the work that the shelters have done to make sure that there are landlines available so that people can make these 800 number calls. I wish I had a better solution for you. It's another thing that we are continually trying to advocate for a better system for. But I think for right now, the main thing that we need to do is make sure that on our end, we are helping people complete these requirements. So they have been told to call this number. We are helping them to call that number. They're being told to present themselves at ICE. We are giving them the resources to present themselves at ICE. So a few things just that I do want to go over is, confirming that they have been placed on parole. So I sort of walked you through the documents that they receive if they have been placed in parole. Those should be the documents that indicate that they have been granted parole. If someone has a different document, hopefully they've already talked to us at the MARC, and we can sort of establish what their next steps would be. So what is parole? Because I've been throwing that around a lot. It's basically the way that DHS has been allowing people to enter the United States. It is not a permanent status. It is not a path to any form of status. As I was saying earlier, it could be beneficial down the line if they do seek a green card through a family or through employment. But it is essentially their permission to be present in the United States for that short period of time. One thing that is important to know is that parole is not renewable in most cases, although I have started hearing some reports out of San Antonio that they may have been able to get extensions on parole. We have not heard anything like that here in Chicago. It is also important that people understand that once that parole ends, they are considered undocumented, and that they may begin to accrue unlawful presence if they have not moved into some other form of status. The duration of the parole, the 60 days that we are seeing, or 15 days, is completely at the discretion of ICE and Customs and Border Protection. If you worked on the Afghan response last year, you know that most of the Afghans were given 1 year. Most Ukrainians have been given 1 year. Haitians, I think, were given 15 days. So it is really discretionary as to how much time they have for this parole. However, one thing that I do really want to stress is that they are not required to apply for asylum only while that parole is valid. They can continue to apply for asylum even after their parole has ended. So again, just putting up some samples here of forms that you will see in people's documentation if they have parole. So they're going to have this stamp, right? They're going to have this one pager with sort of their basic biographic information. The one pager is called the notice to report. Again, if they are staying local, that means they do need to get in touch with the local ICE office. So that could be going in person to 101 West Ida B. Wells and going up to the 4th floor. I have heard some reports that building security has been a little difficult. If it's at all possible to have someone who speaks English go with them to explain to building security, I think that's definitely a good idea, since most people's documents are not going to have local addresses on them. We have also heard of people successfully advocating for themselves to be allowed to get up to the 4th floor. When they are on the 4th floor, we've gotten really mixed results on what is happening afterwards. I have heard that sometimes they are told to come back in 6 months, sometimes they're told to come back in a year. Most people, however, have been given this email address that I have here, which is ICE Chicago reporting at ice.dhs.gov. And they are told to use that information to report to the local office. I have also placed the phone number for the local office on here. When I have tried to call it recently, it is going directly to a voicemail. It is not going directly to their receptionist. I am strongly, though, advocating that people leave messages at that voicemail if they do call. Again, we're really just trying to establish as much proof as possible at this point that people are complying with the parole requirement. So again, I had mentioned notices to appear, right? And a notice to appear being the point where people's deportation proceedings or their court dates begin. We have handed out in everybody's packets a sample notice to appear. When they come through at the MARC, I do double check, I look at their documents, but then I also ask them, have they been issued a document that looks like this? The majority of people have said no. The notice to appear is essentially the form that starts the deportation proceedings. So it will have the reasons that someone is in deportation proceedings. For example, and for most of our participants, it's that they are an arriving alien. It will then have sort of what the allegations against them are, so that they are not a citizen of the United States. They are a citizen of Venezuela. They entered the United States on September 17th in El Paso, Texas. They did not have a visa at that time, and therefore they are in deportation proceedings. The most important thing about the notice to appear is the section at the bottom. And at the section at the bottom is where it will explicitly say when their next court date is. Generally, traditionally, what happens is that ICE will present these documents to them at their check-ins. As I said, we haven't really been hearing a lot of that recently when people have been going to present at ICE. They can also send them to them by mail, which is why we really do want to make sure that people's mailing addresses are up to date with ICE as much as possible. This section here, and I know it's kind of small and I apologize, but it specifically says that you are ordered to appear before an immigration judge of the United States Department of Justice at, and it's going to have the address of the immigration court where they are expected to appear, the date and the time of their hearing. Now, it is absolutely important that people do appear at their immigration hearings. If they fail to appear at their immigration hearings, they will be ordered deported in absentia. There is no sort of warrant system. Failure to appear just will automatically result in a deportation. Now, hopefully, what should happen is that as people present at ICE, ICE will then update their address to a local address here in Chicago, and then their court will be scheduled here in Chicago. If it is not, there are resources on how they can file a motion to change venue, and we can make those available. I think I've sent them out previously, but we have extra copies as well. And then, but however, if they are set in a different jurisdiction and they are not able to change their venue, they will need to travel to that jurisdiction. Again, I do want to make it really clear. This, I think, as I said, only 26% of or 26 people, 26 people that we have seen have even had one of these documents out of the probably close to 1,000 at this point. So this is really not something that is applying to most of the population that we are seeing, but I do just want you to know what it is and what it says and what the significance of it is. Again, as I said, most people have been getting the notice to report, which is the picture that I have on the right side of the screen. Again, that is just that they are obligated to present themselves before the local ICE office. So I've kind of covered a bit of this already, but if they do have that notice to report, they must check in within 60 days or 15 days. There is a website that they can use to change their location to Chicago. I have that website here. My problem with this website is that the last time I logged in to look at it, the next available date was in March of 2023, which is very much outside of the 60 days that everyone has been given. To log into this website, they are going to need their subject ID, which is again on that first page of their documents. If the ICE portal is not reflecting an available appointment during that 60-day period, what we are currently advising people to do is to send an email to this ICE Chicago reporting at ice.dhs.gov email. So in that email address, they need to have the name and full names of any family members who are with them. They need to have everybody's A numbers or their subject ID numbers, and they need to have their current address and a current phone number if they have one. Anytime that they move or change their address, they should send an email to this email address confirming that what their new address is. I am still encouraging people to attempt to go in person to ICE, especially if they have been scheduled for a set date, even if that date is not in Chicago, and to continue trying to call the ICE reception number to try and get through. What I do like about the email address, and the reason why I am advocating that everybody at least attempt this, is that it does create a paper trail. It does create proof that they have sent something to ICE, that they have attempted to comply with the requirement that they report within the period that they have been assigned to report. I have seen one or two people that have been issued I-220As and I-220Bs, but the vast majority of people do not have those. Those are usually issued once they have had their first in-person check-in with an ICE officer. At that point, the officer will then sign it and give them their next date. But I really do just want to stress that I think this email address is our best route, at least until we get any form of other advice from ICE. I have consulted with the American Immigration Lawyers Association, and they have also said that this is what they have seen people receiving. This is what we have seen ICE literally handing people when they go in person to try and check in. So I think that if people are unable to go in person, sending this email at least is establishing proof that they did attempt to comply and that the problem with the problem that made it impossible for them to comply was not caused by them, but was rather caused by the system being overwhelmed. So when they go to that check-in, what's going to happen? Essentially, they're going to confirm their biographical and information and their address information with the ICE officers. If they haven't been issued that notice to appear, they may be issued one at that ICE check-in. And then later after that check-in, ICE will need to file that notice to appear with the immigration court. Now, this can get tricky because sometimes they put at times and dates on the notices to appear that do not actually comply with the court system. I have given everybody the resources to check and make sure that their dates appear in the court system, and we'll go over how to do that as well. Now, the ICE may evaluate their compliance with the ICE requirements. So have they, checked in on time? They may put them on some sort of supervision program. So one thing that is very common right now is that if someone has a phone, they will put an application on their phone. Previously, at times they would give people phones with the apps on them. We're not really seeing that right now. I think numbers probably have a lot to do with it. And essentially what they are telling people is that every Wednesday from 8 a.m. to 11 a.m., you need to take a picture and upload it, take a picture of yourself and upload it to the app. And then they're using the metadata from that photo to prove that people are where they are supposed to be. So they are essentially checking in via geotag. Usually what happens is that the ICE officer at that time will tell them when their next ICE check-in appointment will be. I have seen ICE appointments be 3 months out. I have seen them be 6 months out. I have seen them be a year out. It really is at the discretion of the officer how long that next appointment is going to be. I do really want to stress that it is not necessary for migrants to be accompanied by an attorney to these ICE check-ins. The best sort of example that I can give you is that they are on parole, right? And so this is essentially the same as checking in with their parole officer. So not that I like this illusion, but if somebody was in criminal proceedings and they were on parole for their criminal case, they would check in with a parole officer periodically. They would not necessarily bring their attorney to check in with their parole officer. Essentially, this functions the same way, and that our participants are here in the United States on parole, and they need to present themselves to these officers to establish that they are in compliance with their parole. So for the most part, they do not need to have attorneys go with them. I have had reports of attorneys who have attempted to go with and were not allowed to enter the space with the participants. The only times that I personally have gone with clients to their ICE check-ins are when I do think that there is a very high chance that they will be deported or detained. Other than that, for the most part, my clients have always been able to go to these ICE check-ins by themselves. And honestly, even when I do go with my clients, most of the time the officers ask me why I'm there. It is not a confrontational check-in. It is really just about confirming their information and confirming that they are in compliance with the parole. So if they are issued that notice to appear, so the beginning of their court proceedings, they are probably still likely required to check in with ICE within those 60 days, right? Again, they are still needing to show that they are in compliance and that they are following sort of the directions that they have been given. When we meet with somebody who has a notice to appear, the first thing that we want to do is confirm that their court date is real and not what is colloquially referred to as a dummy date. So the two ways to do this are by calling this 800 number or by going to the the EOIR website. You're going to enter that A number. So again, that alien number or file number, and it's going to tell you straight out if the person has a court date, what that court date is, where it is, and what the judge's name will be. If they do not actually have a court date scheduled and the court date on the notice to appear is not a real date, it will say that this number does not exist in the system. One thing that I will add is that I have seen a few court dates which are set for August of 2023. They are not currently in the court system that far out. That could change. It is really important that people know to call this 800 number to monitor whether or not they have a court date, whether or not that court date has changed. There has been quite a lot of litigation about dummy dates. It has gone all the way up to the Supreme Court. Essentially, if the court date is not real, if they are later put into immigration proceedings, the immigration judge can terminate their proceedings because they were given a faulty charging document. So these court dates and these dummy dates can be very confusing, but really the best guidance I can give is for people to call this 800 number. It is in Spanish. They can also go to this website. It is available in Spanish. We do give everybody all of this information when they check in with us at the mark. And again, if someone does not attend their court date, they can be ordered deported in absentia. So it is really critical that they attend their court dates. Now, one of the questions that we are getting a lot is, can people work, right? This is everybody's main concern, is, are they employment authorized? Most of the people we are seeing are not eligible to work. Now, technically, if someone has been admitted on parole, they are allowed to seek employment authorization based on that parole. However, the employment authorization will expire on the date that their parole expires. So it cannot exceed the length of the parole. So for most of our applicants or participants, they've only been given 60 days of parole. They are not going to be able to get an employment authorization document before that parole expires. Right now, it is taking 10 months for USCIS to approve employment authorization documents. And again, the participants that we are seeing are only being given 2 months. So while people who are on parole traditionally can apply for employment authorization, for the people that we are currently seeing at the mark, they are not going to be able to get that employment authorization before their parole expires. And at that point, they will not be employment authorized. It is important to know that people who apply for asylum can apply for employment authorization, but their asylum application has to be pending for 150 days before they can submit, so 5 months before they can submit that application for employment authorization. That being said, I think everybody on this call is aware that there is a large undocumented population in this country and that they do manage to feed themselves and their families and support themselves. When people ask me about working without authorization, I just tell them that to work legally in the United States, you need to have an employment authorization document. I let them know that working without employment authorization can be risky, that if they use any false documents, there can be criminal liability. And the one thing that I really do stress for people is that they absolutely must not say that they are US citizens to get work. Making a false claim to US citizenship is a deportable offense, and there are very few, sorry, I'm thinking in Spanish. There are very few ways around that deportation. There are very few forms of relief from that deportation. The other thing I do remind people, though, is that all workers have rights and protections. It doesn't matter what their immigration status is. They should not be abused by their employer, and that they should be aware that they have rights and protections. Again, all I can really fall back on is to tell them that they are not legally authorized to work without an employment authorization document. And I know this is very hard for a lot of people to hear, but it's honestly very hard for me to say it, but that really is all that we can tell them, is that if legally they are required to have an employment authorization document. If they do get a work permit or an employment authorization document, then they can use that document to get their social security number and their driver's license. A person will need to have that employment authorization to get a social security and to get a traditional Illinois driver's license. Now, Illinois, we do have the temporary visitor driver's license, the TVDL, also known as the temporal in the community. To qualify for that temporary visitor driver's license, you do not need an employment authorization document, but you do need to establish that you have resided in the state of Illinois for at least 1 year. So that may be something that is available to our participants later on, but currently they are not eligible for those documents. So what do they need to do to make sure that they are complying with requirements if they end up in immigration court? Again, I really want them to make sure that they are checking this 800 number, that they are checking the online portal to make sure that there have been no changes to their court hearings or that they have not been placed in removal proceedings. I will admit that one thing that makes me nervous about this population is that they are going to be moving quite a bit. I worry that they may not receive notices to appear if they are sent to them in the mail and they have not updated their address with immigration or with the court. I have been telling everyone that they do need to check either this online portal or call this 800 number once a week to see if deportation proceedings have begun against them, and to find out if they have court. Because as I've said, it is absolutely critical that they attend all of their court hearings. If they do not attend a court hearing, they will be ordered deported in absentia. There is an ability to file a pro se motion to change venue if they need to move to a different city or their court is set in a different city. Usually, as I said, right now, most of the people we have seen are not going to be in that posture. But if they are, there are resources. Our immigration court help desk is one. I've got their phone number here, which is 312-660-1328. And they also can help people with pro se motions to change venue. They cannot represent people. They do not provide legal advice, but they can provide sort of general advice. So they have template pro se motions to change venue. They can give people sort of summaries on what will happen at their first court hearing, and give them sort of guidance that way. Generally, the first court hearing is the master calendar hearing. So this is a status hearing. It's the calendaring hearing. Usually at this point, a participant can request more time to find an attorney, or they can explain to the immigration judge what their preferred next steps are. So if they're going to be applying for asylum, or if they want to take voluntary departure, or if they need to file a family petition, those are all things that they can present at that first hearing. At the first hearing, they will then be calendared for their individual hearing, which would be when they will actually fight their case in front of an immigration judge and present all of their evidence. Prior to COVID, it took about 4 years to get an individual hearing. We have not had very many individual hearings for the last 2.5, almost 3 years. So I suspect that when we start having master calendars again, there may be a long wait for an individual, but we will have to see how the court decides to handle these cases. I know I've thrown a lot of information at you right now really quickly. I really want to come back to right now what we need to do with the participants that we are seeing, and that is put them in contact with the Department of Homeland Security. So if someone wants to find out if they have immigration court, they can call this phone number. You press 2 for Spanish, put in your A number, and it will tell you if they have court or not. Or you can go to this website, you can put in their A number, and it will tell you if they have court or not. To present themselves to the local ICE office in Chicago, really do want people sending an email to this email address with their names, A numbers, and current address and phone number if they have one. That's the thing that I really want people to make sure that they're doing within these 60 or 15 days. I am still advocating that people go in person to 101 West Ida B. Wells to report to Chicago, because we have not heard otherwise from the local ICE office. I am very hopeful that we will hear something official that will tell us one way or the other what we should be telling people to do. As I said previously, the email is really what I would like people to be doing because it does lay a paper trail. But going in person also hopefully would create some sort of a documentation trail as well. Really briefly, I do want to discuss some common forms of relief that people may see. So, asylum, temporary protected status are 2 that we are getting asked about a lot. For asylum, people need to prove 3 things essentially: that they have been persecuted or have fear of persecution, that their government is not able or is unwilling to protect them, and that their harm was based on their race, religion, nationality, membership in a particular social group, or political opinion. Membership in a particular social group can include multiple things. So it can include gender, it can include sexual orientation. Political opinion also can include an imputed political opinion, right? So they're pro-American or they are anti-Maduro. I have seen a lot of people who have told me that they are musicians who sing anti-Maduro songs. That may be grounds for asylum. And so we do really want them to look at exploring asylum applications. sorry, this is my slide on particular social group. Again, so there are a variety of things that can fall into particular social groups. So past employment. One thing that we see a lot in Venezuela are attorneys who may have come in contact with the Maduro government and are being persecuted for that. Again, musicians is another one. Again, gender, sexual orientation, those are all really important things that people may not necessarily think of that do qualify them for this protection. Now, I do want to add that an individual is not eligible for asylum unless they can show that the harm was because of a protected ground. So one thing that I am hearing a lot of is that people are fleeing generalized violence or they're fleeing because of the economy. Those things themselves may not be sufficient to qualify for asylum. But I do really want people to explore, what their possible recourses are. And again, it is critical that asylum application be filed within the first year. Right now, because they are not in deportation proceedings, most people are going to be filing affirmatively with U.S. Citizenship and Immigration Services. If USCIS's asylum office denies the case, at that point, they will be put in immigration court. They will be in deportation proceedings. So they kind of have two bites at the apple. Briefly, I have information here about temporary protected status. This is a sort of blanket humanitarian relief. It's issued to non-citizens. It is a temporary status as designated as in the name. It's usually only designated for 18 months. This is where things get confusing because there is temporary protected status designation for Venezuela. However, to qualify for that, they have to show that they were physically present in the United States in March of 2021. So nobody that we are seeing is going to qualify because they don't meet that physical presence requirement. And this is really a horrible thing to tell people because they all have heard about the PSA. And unfortunately, the way the current designation is, they do not qualify. It is even more confusing because the White House has recently announced that they are going to allow renewal of temporary protected status for Venezuelans, but that is only for people, again, who met that March 2021 cutoff. It is not an extension or a creation of a new cutoff date. People who do have TPS can still apply for asylum. In fact, I do generally encourage people to apply for both. TPS does allow protection for from deportation for 18 months. It also allows people to work. So it is something that I do generally encourage them to apply for while they are pursuing asylum. The U visa is an option. It is available to people who have been victims of violent crimes here in the United States and who have assisted in the investigation or prosecution of those crimes. Right now, most of our participants, I don't think / really hope would qualify for a U visa, but as they are here longer in the United States, if they do become victims of these crimes, I do want to encourage them to consider a U visa. Hopefully they will never be in that posture, but it may come up. A T visa is another visa that is available for victims of severe forms of trafficking. I do know that we have had a couple referrals already from Salvation Army for people who have been trafficked, and I do want to thank you for identifying those and sending them over for screening. Essentially, to establish that they are eligible for a T visa, they have to show that they are physically present in the United States on account of that trafficking. They have to comply with any reasonable request for assistance in the investigation or prosecution of the trafficking, and they have to show that they've suffered extreme hardship involving unusual or severe harm if they were removed from the United States. It is unfortunate that we have already seen people who have arrived on the buses who have been trafficked. I unfortunately suspect that we will continue to see more people, but this is a visa that is available. It is a protection from deportation, and it can eventually lead to adjustment of status and receiving a green card. Another thing that we are seeing that may apply is special immigrant juvenile status. So this is a form of relief for immigrant children who were abused, abandoned, or neglected by one or both parents. One thing that is important to note is that in the state of Illinois, the definition of immigrant children goes up to the age of 21. So when we are seeing a lot of these young single males who are coming in, who are between the ages of 18 and 21, they may be eligible for SIJ status. The things to remember with SIJ, however, is that they do need to get some form of legal guardianship from someone here in the United States. And one of the more difficult aspects of it is that they are never allowed to apply for either of their parents. Even if only one of their parents has abused or abandoned or neglected them, they can never apply for a green card for the other parent as well. So it is something that is available, but there are some hard choices involved in it for a lot of our young people as well. Again, I just have this information in here. Really, if people are coming to you right now with questions, I would encourage you to refer to this slide. They have this information in the packets that we have given them already. But if they are telling you that they are worried that they have court, please just have them call that 800 number. If they are worried about how to report here in Chicago, please just go ahead and send that email. And I will continue to update everyone as we get anything further from DHS and from ICE about what next steps will be for reporting. I know we've been working on it. We've Congressman, most of the Congress people for the state of Illinois have been involved at this point. I know Senator Durbin's office has been involved. We are really trying to get some sort of answers, because I know not having answers is just horribly stressful for all of us, particularly for the participants. And so as I get more information there, I will let you know. I am going to stop sharing my screen now. I see that there are a couple questions in the Q&A. So there's a question about, will there be updates to the intake documents the staff are using with their software on laptops? The only options are for Venezuelans currently, but we have other countries present. I don't actually have an answer to that. I don't know if there's someone from DFSS who would be able to answer that, just because I'm just sort of more on the immigration side. And then there's a question about, will the deck be provided to attendees? Yes, I will provide the deck to attendees afterwards. Are there any other questions? If people want to raise your hands, I can unmute you, or at least set you to allow to chat as well, or allowed to talk. I know this is a lot of information I threw at you quickly, but I also don't want to take too much of your time. Okay, Edith? I'm sorry, Edith, I can't hear you.
Yeah,
I'm not sure if you're. Oh,
Can
there
you
you
hear
go.
me?
Okay, you're a little faint, but yes.
Okay. So I just wanted to know regarding the addresses, what would you tell them about the address? How do you handle that?
So I think that's a larger discussion that we need to have. My understanding is that we have been having them put the shelter address as a temporary address, but making it clear that that is a shelter and that they will be moving on from that address soon, and then updating it to whatever address they end up at. It does need to be their physical address. It can't be a mailing address. So yeah, it's definitely a tricky point right now.
Okay.
Maria Gonzalez.
Yes, hi. I have two questions. One question is, if they have 60 days to, if I heard right, for immigration, but they went to immigration and their appointment is until February, are they in jeopardy of
No.
being deported? Okay.
No, so if they already went to immigration and immigration told them come back in February, they are perfect. They are golden. They are my new favorite people.
Okay, great.
Yes.
The other question is, are we monitoring who has or has not gone to immigration, or have you made any announcements to them to remind them? Because I see a lot of confusion with families that are coming in and questions, and I'm worried like you that they may miss their mark and be deported, and then they've been through so much already. So are we to make announcements, or there's a database to find out who has appointment and who hasn't? Anything like that?
I am not sure on that. My contact with them is at the mark. And at that point, most of them have not yet had contact with immigration because this is their first or second day in Chicago. Not sure if that's something that could be tracked, in all honesty, especially because people are sort of so far spread out.
Yeah. I guess that intake.
That's a good question.
We can
Yeah,
ask, yeah, I can ask or remind them as I see them.
yeah, that
to
would be
be on
great.
that. Yeah, okay,
Yeah,
thank you.
thank you. Mhm. Anybody else? Okay. Yes, Geraldine.
Hi, yes. Can we make sure that the immigrants get the information in the right language, like all documentation? I know that we have been providing those in English, but it's very difficult for them. So for decision-making purposes, I think it's very essential to have those documents provided in Spanish for this group or with whichever language for immigrants that is concordant to what they speak.
I'm not sure which documents you're referring to. I know everything that I've been giving them has been in Spanish.
Okay. Perfect.
And for
So that was
the,
my concern initially. Yeah.
yeah, for the documents from DHS, yeah, I've, one of the things that we do is read them to them in Spanish when they meet with us. But yeah, at least everything I've been giving them has been in Spanish. Yeah. Do we have any other questions? Okay. If that's everything, I'm gonna I'll stick around if anybody else has any questions that come up. I am gonna, oh, there's a couple more in the Q&A. Let me see. Okay, if someone has been trafficked, is there a way to identify that if they are too scared to say? It can be challenging. I think there is a level of trust that is required for people to start talking about what their experience was. Um, it may take some time to get them to the point where they are comfortable talking to you about whether or not they were trafficked. Generally, if it sounds like someone was here in the United States, sort of on account of the trafficking, so as they're telling you their story, if they're telling you that they were used to carry bags into the country and they don't know what was in those bags, that's one that we see pretty frequently. I know most people think of trafficking as sexual, but it can also be employment based. There are other forms. Labor trafficking is an option as well. So I think if someone does start to open up to you about their journey, and about any coercion that they faced during their journey, that might be a good way to sort of identify if they might have been trafficked, but it is very hard. Yes, Maria, let me unmute you. My apologies. Maria, I think you can unmute yourself. I don't think I have that. Saul, how can they change the date or place where they have to report? So again, that is going to be with them contacting the local ICE office. It's going to be going in person, or it's going to be sending that email address or that email to that email address and letting them know that they're here in Chicago and that they need to change their reporting to here in Chicago. Maggie, is there GBV screening involved with intake, and does that impact their status / how they are filing? I'm sorry, I don't know what GBV stands. Oh, gender-based violence. Sorry. So we are not doing active screening right now to look for gender-based violence. Like I said, we're really just giving orientations and giving people the resources for the next immediate steps. I'm not sure if the screening that the city is providing is looking at gender-based violence. I know ideally, we are hoping that we'll be able to move into the shelters and do something more in depth at that point in the future. And at that point, it is something we do generally screen for. But I think at this point, I don't know that it's being actively screened for. All right, I don't see any other questions in the Q&A. I don't see any other hands up. If that's everything, I think we can go ahead and wrap it up. I will send the slide deck, I think probably to Kim, and have her disseminate it out to you all. Thank you again for joining me. Thank you for all of the work you're doing. It's been amazing, and I cannot thank you enough for all of your work.